Dr. M. Thambidurai.
Yes, sir.
I am sorry.
Mr. Chairman, sir, now we have taken the National Judicial Commission, Appointment Commission regarding that. Sir, in this, why we have taken seriously and discussing this bill? Recently, we have come across certain retired judges given certain opinion how the collegium is functioning. That is the true history. Because a former judge, Gadju, he raised the issue, the interference, the political parties' interference in the appointment of judges. Because certain political party pressurized the judge to appoint one high court judge, that issue started. In that, former law minister also accepted that. That news has come. The former law minister Bharadwaj himself gave the statement, yes, the DMK sought extension of a high court judge. That is the problem started. Therefore, when some political parties to take advantage and they pressurize the collegium, therefore collegium also yielded to the pressure. That is what we have seen. That is the news. Therefore, the collegium we cannot say is a superior one. That is not a superior one. That is our view. That is why, sir, I also served as a law minister. You know very well. What are the experience also I faced those days is a well-known fact. How that collegium, they take the decision, and how they bypass the executives, and how I suffered at that time also I know very well. But the thing, sir, I want to make it certain things, because our Honorable Chief has written a letter to the Law Minister about our party's view. That I have to express. This is our stand. Sir, as far as the ADMK party is firmly committed to upholding the independence of judiciary. Our party is that. Even our law minister said judiciary must be independent. That we are for that, because people must not think the parliament bringing certain rules and regulations and law to have certain vested interests. That must not be there. Therefore, we are fully for the independence of the judiciary. Our party is that. What our Chief Minister returned to the Law Minister also. Sir, at the same time, the executive role, because we are of the view that the extent, procedure and practice regarding the appointment of judges of Supreme Court and of the High Courts is not keeping with the spirit of the Constitution provisions, as the role of the executive has been effectively taken away. That is the issue. We are for the executive must play a role in appointment of the judges, giving the opinion. That is what our Chief Minister returned to the Honorable Law Minister. Sir, this is in other democratic country world, do you have a situation where effectively the judiciary appoints itself? Only judiciary, they are taking their own thing. They are appointing their own judges. Sir, in that, our Veerappa said regarding the All India Judiciary Service, it's a good suggestion, what he said. Because what really happening, the collegium, they are selecting own people, even going to certain judges recommending their brother-in-laws, sons, all like that, their family members, you can see that they are becoming judges likely continues going on. That is what is happening. Therefore, where is the talented people? These people all may be talented, I am not denying that. Because what happened 1993, before the appointment, this collegium role, what even Moily said, so many eminent judges he said, there we had such kind of judges. Therefore, the collegium after that 1993, when they have taken, they could not produce not less than what we had previously also, previous judges. Therefore, they cannot say the collegium is the very superior one, and they are finding a talented people, and also they are not giving any importance to it is there. Therefore, our approach, the collegium, is not, we are not fully accepting what our Chief Minister has written. That is what she said. Experience since 1993 with the present practice of judicial primacy in judicial appointments has also shown us that the outcome in terms of quality of appointments is not significantly superior to what prevailed in the period prior to the 1993, when the executive had an important role. So regarding what our Miley said, that is a good suggestion. All India Judicial Service is a good thing, because when we are having that system like IPS, IAS, there may be reservations also will be there. When there is a reservation, then SC, OBC, all categories can be taken into consideration at that time. But in that process, how they are appointing, they are not taking those rules. There are some judges they are appointing. We can't find SC people, OBC people, and women. They are not able to get the full representation. What is collegium doing? If at all India service like the IPS expert, promotion will come. When they appoint at district level, they are having a full experience. After that, they are giving promotion. Like we now, what is happening? The lawyers also appointed, because when senior lawyer is a private practicing lawyer, for example, our law minister, he is also practicing lawyer. If suppose he becomes judge, then what will happen? His juniors who all served under him and his clients were at cases, then how he will give the judgment at that time when you are sitting as judge? You are a human being. You cannot be like God. See, when you are going that, therefore practicing this kind of lawyer, sometimes there may not, I'm making aspersion, but practically if you think as a human being, naturally there may be some kind of influence also in judgment. Therefore, this is All India Judicial Service, if you bring, if you make it, that is the good reform if you are making. Not this kind of national duty, it's not going to serve any purpose. I'm telling you. This is what now you are bringing, it won't serve the purpose. It's a fact. You must bring a fundamental change in the system. Then only we can get real kind of jurisdiction. Otherwise, there must not any may not be there. If at all when their promotions are coming, then afterwards there can High Court judge, they can become. Then afterwards the Supreme Court judge. Like that, they come automatically, the IAS officer, become promotion. Then they cannot, these lawyers who are practicing are becoming, there will be whims and their fancies also in that. Therefore, this system is a good system. If you bring that kind of system, we are appreciating that. That one thing. Regarding that, after the retirement, these judges must not give this kind of any appointments. That is the problem. Becoming governors or some kind of, you are putting like that, they are also influenced after some time. Because when the government is there, the government at that time, they are having some people, I'm not blaming you, one or two people having some kind of role play to satisfy existing at that government and try to become, after retirement, they may try to get some kind of post. Therefore, we have to totally ban. Even when they were TRI chairman, we are to bring Misra, at that time we banned amendment. That's even TRI itself, when you are putting a condition, after some time they must not go any government service. What about the judges? There we are telling the above everything. This, if you are allowing these judges after retirement to get some kind of government post, that is not correct. Therefore, committees, panels you can appoint, that is different. But giving the appointments, like executive power, they are coming. Therefore, that kind of power must not be given, that those just must. Therefore, if they are coming promotion, rehabilitation. Therefore, it is not in their post cannot be rehabilitated centers for them. Therefore, I am telling this is also that if you bring this kind of All India Judicial Service, this can be stopped. That is what suggestion is good suggestion. And also, as I said, the reservation, everything will be implemented. So regarding, we have said further, the judiciary is an important organ of the state and must reflect the diversity of Indian society in order to be sensitive to the socio-economic realities of the country. Hence, it must adequately represent different regions, classes, and communities, and in particular the weaker sections, minorities, and women. Such concerns are more effectively addressed only if the executive also has an adequate say in the appointment of judiciary. Sir, this is all right. Judiciary, you are we are executive, we have to play a role because people, the executives are elected by the people. The parliament is supreme here. Therefore, when we are making legislation, we are representing the aspirations of the common man who voted for us. For that only we are interfering, or giving our suggestions, not interfering, we are giving suggestions in the appointment of judges. What about the state governments? That is our concern. The state governments must be given due proper representation in appointment of judicial judges. Because they are the state governments are the real government implementing the programs and moving the people. Even the center and the parliament are passing so many laws and legislation, all executed by the state governments. If you are not giving the proper representation and their say in the appointment judges, there is no meaning of bringing up this kind of National Judicial Commission. That is what our Chief Minister has written here. I therefore strongly recommend that the Judicial Appointments Commission should function at two levels. One is national level and at the state level. National Supreme Court you are appointing, that is okay. We are not objecting that. That national judicial, we can do it. What about our High Court appointments? Where state level so many issues are involved. There also we are having a legislative assembly. There's a council, we have so many other state councils they are having. Those people are elected there. Therefore, here what we are requesting you, please this national level, at the state level also you have to given that kind of power, appointments of the High Court judges. That is what we are insisting. That is what our Honorable Chief Minister has written. Sir, for judges of High Court, a state level judicial commission should be created. But this bill is not giving that. No, that state level high committee there giving. No, not asking the view. As you are appointing as National Judicial Commission here, we want state level Judicial Commission also, where the Chief Justice and other senior judges and Chief Minister and Governor, there must be, our representatives must be there. For what? Appointment of High Court judges, selection there. No, Supreme Court is different there, I am telling. No, state level. State level are asking, state level, which you are not given, because that is the elected court. That is our view. That is why we are fully not accepting this bill. No. That is, sir, here, our view, when you are not giving proper thing, there is no point on supporting this bill. That is the decentralization. But we are, that is why we are, our Chief Minister written. Also, I am expressing our view here. Therefore, unless you are creating that state level also this judicial commission, our party may not in a position to support this bill. We are not. That is what, because that is, we are telling a federal system of the country, you want to already BJP, India government promised, they want to give more to our states and bear the role. But where is, you show this in this bill also. That is what we are expecting. Otherwise, we won't support. Unless you give some amendment, I have already given amendment also. The amendment may become. Therefore, unless you accept our amendment, our party is not in a position to support this bill. That is, please take our, then you are taking, we are supporting this bill also. Take the consideration, this amendment, what we are asking. In that, what we said, the members of the state level commission could be as follows. Chief Justice of India, 2 nominees of the judiciary, a Supreme Court judge nominated by the Chief Justice of India, and Chief Justice of the concerned High Court, the Chief Minister of the state or his nominee, 2 eminent persons who are not judges, selected by the collegium comprising the Chief Justice of the High Court, Chief Minister of the state, and Advocate General of the state. We are of the view that the composition of the commission should be provided for the Constitution itself. The Constitution, we have to give the Constitution, that is what. That we are expecting. This has to be given. Otherwise, what is the use? As you said, UPA government brought, you at the time opposed. Now you have brought UPA, I don't know whether going to fully support or not, we don't know. As our concern, both parties, you cannot, but don't neglect our regional parties. You have to give the opportunity for us to say, for that only I am insisting, this state level level commission must be required. That also given in constitutional amendment I require. That is why I given that. I am given. Now, All India Party. That is why I am expressing a letter. Already my minister is having my chief minister letter. He also said to me, therefore, please go through that, what we are expecting. We are certain things we are advocated, what you have said, we expressed, we are also appreciating that. Executive must play a role in the appointment. We are not denying that. But whatever the state role, that is, you give some kind of constitutional amendment and give the guarantee, then only it will be easy for us to take. Therefore, Clause 5 of the Judicial Appointments Commission will provide for the eliciting the views of the Governor, Chief Minister. What you said, this I am telling, this you have said, this is what? Clause 5 of the Judicial Appointment Commission will provide for the eliciting the views of the Governor, Chief Minister, Chief Justice of the High Court of the concerned state in the case of appointment of judges to the High Court. However, this is what I am saying, however, there is no clarity on the manner in which these views would be treated. See, you can ask, then afterwards you can take our own decision as a veto power. Then what is the use? Then namesake sending every formalities as I also, you are law minister, I was also law minister. Some file may come for the minister, then it will go. Then judges will take the final decision, the law minister only clerk, signing and sending. Law minister became a mockery from 1993 onwards. I don't know what Meerapumeli faced till now. I faced, I'm telling. I think you are also facing the same thing. We are not clerks. We are elected people. We are the executive authorities. Then when we are demanding such kind of respect for us, we are represented. That means respect not for us, means for the people. We are the elected by the people. We are there. Therefore, when that case, what about the state government? That is why we are telling there are the elected people that getting some formalities, and if you take final say without giving consideration to the chief minister's view or that thing, there is no point. So become a formality, it will become. Therefore, that is why we are insisting you give some kind of amendment or provision in the constitution itself, then only it will be useful and it will be appreciated by us. Therefore, state government's view against any proposed appointment ought to be given due weightage, and a provision in the legislation should be made to ensure that appointments which are opposed by the state government are not proceeded with. That is what is given. That is the clause we are making. Clause 5 should be further modified to provide that the governor, state government, and chief justice of the High Court of the both states to which a candidate belongs and the High Court to which the appointment proposed should be consulted before appointment. This has to be done. Other if it's not the gun, what is the use? That's what this is also serious issue our madam has raised. The manner in which the commission recommends will be made have not been indicated in the bill. It is not clear whether the recommendations are to be based on the unanimity, consensus, or majority, and in the case of majority, whether it would be a simple majority or a qualified or superior majority. Don't know that. It is not made clear. It may be advisable to spell out such a rule in the legislation itself rather than have any confusion in the interpretation at a later stage. Ideally, such a rule had to be a superior majority, wherein if any two members do not favor a proposed recommendation, it shall not be made. Sir, in Judicial Standards and Accountability Bill, the scrutiny panel is proposed to be an exclusive team of judges, whereas in the Oversight Committee, 3 members are serving or retired judges. One is the Attorney General, who is also closely connected with the legal and judicial fraternity, and the last member is an eminent person nominated by the President. The Oversight Committee is vested with the power to choose the Investigation Committee. In these circumstances, such an overwhelming representation to the judiciary in the crucial panels intended to exercise oversight, most of whose proceedings will be shielded from the public gas, appears to be a violation of an elementary principle of natural justice. Sir, that no man shall be a judge in his own cause. Hence, it is essential that there should be more persons of high integrity and eminence from the civil society in both scrutiny panel and in the oversight committee, so as I eliminate any impression of bias. Therefore, our Chief Minister hopes that the views of the ADMK party will be taken on board and necessary further official amendments made in the three bills before passing the Parliament. This is our view, sir. That is, thank you very much.